Good morning. Happy Thursday.
Happy Thursday.
Can I hear you okay? Good. Man, I got to tell you, it was cold this morning.
I know, I know. I'm not used to this.
I just turned my heater on my house. This is stupid. I'm
We
going
had
to
ours on last night.
put
Yeah, no, and it's funny because I'm from Michigan, but I'm like, as soon as the temperature drops, I'm not used to it anymore. I can't handle it.
Oh my goodness. Okay, so your name is Jennifer Chapman,
Yes,
and we met at an Easter Seals function where it was awkward. They made us do a speed networking game,
they did.
and we had to sit around the table and go around and introduce ourselves to each other and find out what we did for a living. And I had just literally that week signed all of my assets into a trust.
Okay.
And you work for a very well-respected firm in
It's a great
Tampa,
firm.
Bush Ross,
Yes.
and you specialize in wills and trusts. And I'm like,
Yes.
what a small world. So this is an important thing. And as we're real estate agents and we deal with the public, we don't spend a lot of time, we don't certainly give advice, but we certainly should mention some protections that are available to our customers.
Hmm.
I thought, what a neat way for you to get some exposure for your business and me to educate my people, and called teamwork.
I love it. Go team, go.
So go ahead and give us a brief introduction about yourself and your firm, and then I'm
Sure.
sure you've got something planned you want to tell us. If
All
not,
right.
I'll ask you a bunch of questions.
Oh yeah, I'm here for questions. So my name is Jennifer Chapman. I work at Bush Ross. I'm an attorney there. I've been an attorney with Bush Ross for about 4 years. I'm a shareholder. My practice focuses on trust and estates, taxation, and business entities. So my before I worked as an attorney, I was at Ernst and Young. It's one of the top three public accounting firms in the world. I was a senior manager there, and I was doing the more numbers tax side of what I'm doing now. So I was doing some tax planning, that's income tax planning, gift tax planning, estate tax planning for super ultra high net worth individuals, and also pulling in their businesses as well. Just because in this area locally, I find that a lot of folks are just very entrepreneurial. So kind of having a handle on their business taxation and business planning is something that I've done, back on the accounting side and also here at Bush Ross. So my focus is trust estates, tax, and business, but my firm does everything pretty much. So I guess it's old language now, but we're a full service law firm. Been here since 1981, I think. So very well respected, a lot of really smart people. Here to help, here to talk to you guys about anything, whatever. Just shoot me an email, let me know. But that's a little bit about me. Oh, from Michigan originally, and I've been in Florida for almost 20 years now. So
We're in Michigan, just for fun.
Yeah, Pontiac, Michigan. So it's about 45 minutes outside of Detroit.
Okay.
Yeah.
We have family in Lansing, Michigan.
Really? Very nice. Small world. Small world.
Is that close by?
I've gone there before. It's the capital. It's a few hours away, but it's not crazy.
It's still cold.
Oh yeah. Oh, it's always cold. You get like 2 months of warm weather and it's ridiculous. But Florida's good.
Where in Florida do you live?
Right off of Euclid and Dale Mabry. So do you know where Britton Plaza is?
Oh yeah.
So literally we walk across the street to Britton Plaza to get our groceries at the Publix.
So you're
that's where we are. Yeah, we've been there for about 6 years now. I moved in when I was very pregnant with our twins, so which was challenging.
And of course, you own your home, right?
We do, yeah.
Your home to trust.
It's not in the trust.
Oh,
No, 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 no. So I don't typically put homes in a revocable trust because one, I do separate trusts for husband and wife, just because I find that joint trusts are unreasonably difficult after one spouse passes away to kind of sort things out and make changes.
see, there's always a twist.
There's always a twist. Like people come to me a lot and they're like, oh, we want a joint trust, because they think it's going to be more efficient or less time consuming, whatever.
As long as you plan on dying together, I guess it's a good idea.
If you're dying together, but let's hope that's not the case. I don't know. Maybe it is better you die together, but typically I do separate trusts, and I do not put a home into a revocable trust Just because I find that I don't want to do anything else to cloud title when it comes to homestead property. And also because typically after you pass away, your property, if you want to sell it and get clear title, it needs to go through probate anyway, if you want to maintain those homestead protections. So putting it into a trust to avoid probate or to transfer the property, for me, doesn't really seem to pick up that much in the way of efficiency. And it often complicates things at the end. So what I would prefer to do, and what I do with my clients, unless they absolutely insist on putting it into a trust, is I speak to them about all of their assets, understand what they have, and try to make sure that everything else they own can be transferred outside of probate. So that once they do pass away, we get to the probate process. If we need to do the probate, the only thing we need to do is really get a homestead order that's easy in and out, and they're on their way, as opposed to having all these little bits and pieces everywhere that they have to like figure out and get it through homes and get it through probate. So that's what I do.
You know what? Let's take a little step backwards because,
Mhm.
and no discount to real estate people at all, because we love them dearly. But to become a realtor, it takes 63 hours of classroom education.
Mhm.
And then you take a test in that class, and then you pass the state exam, and you are officially a licensed real estate salesperson.
Mhm.
So a lot of times and I can admit to this, I've been a broker for 32 years and I'm still learning new stuff, right? After all the experience I've had. So a lot of agents, we don't want to sound stupid, not knowing what that. So let's take a step back. Let's talk about just normal life. John and Mary go through life and something happens. They own their home. They worked hard to pay it off, or it's close to paid off, and something happens and one partner dies or not, or another partner dies. What are the steps they have to go through? Especially we as real estate people know,
Mhm.
when somebody dies, what do they have to do? The exercise, what brought us together was when you and I met, I shared an exercise we do with our agents called the green box exercise, which
Mhm.
is putting all your affairs in order so that in the event of your untimely demise,
Right.
they don't have to go hunt and peck for your password to your bank account and all that other stuff.
Mhm.
Right. So maybe as an attorney, you can give us some of the steps people go through when a death happens, and then how you can help us plan to make that less painful,
Right.
or how the deceased person could plan to make it less painful on their loved ones.
Sure. Yeah. So when a person passes away, the first thing when I get a phone call, my spouse has passed away, my mother's passed away, sibling, whoever has passed away, what should I do? The first thing I ask is, do they have a will? And if they have a will, awesome. Do you have the original of the will? Yes, that's good. If there's no, then it's a little more complicated, going through the probate process. The next thing I do is ask them,
Let
okay,
me clarify. So
Mhm.
you need the original wet signed will.
Exactly, yes,
So I
that's what the court
scan mine, put it
requires.
into Google Drive to make it accessible, but that's
Mhm.
not going to be good enough. I'm going to have to actually have an
So
original one.
right, so it's good that you have it scanned and that that copy is available to everyone, but the priority with the court is the original signed will. So you'll need to keep that in a safe place somewhere and let whoever's gonna be your personal representative know where that is. So safe deposit box, a safe at your home, wherever, but keep it safe and let someone know where it is. Because that needs to be taken to the court and deposited with the court. If they do not have the original and they just have a copy of it, that's better than nothing. But the court is going to require you to take extra steps to prove that that will is a true and accurate will. And the more steps means that there's going to be a hearing. That means that you're going to have me as your attorney who has to find the people who witnessed the will, the notary, have outside conversations with them, walk them through the process, basically interview them, because the court assumes that if you don't have an original will, then you destroyed your will during your life. And so that will shouldn't be active. So then me as an attorney, I have to basically go through the steps to prove, no, he did not destroy his will. He did not mean to change his will. We just don't have the original copy of it. But we do have these people here who witnessed it and this person who notarized it. And they're going to provide testimony to you saying that this is a true and accurate will. And so it can be done. I've done it several times. It just takes extra time and extra money. And that means that's money that's not going to your family. It's going to me, it's going to the court. So keep that original will
And that
with.
assumes that the witnesses and the notary are still around.
Right. Yeah. I've had some
Wow.
that are not around, like
See, I learned
some of these
something new
attorneys are
today, guys.
retired.
So did you.
Yeah, so I mean, it's one of those things that, look, it's one of those things on the front end right now. Whenever I do an estate plan, I say keep the original will, and this is why.
Now,
Don't
do
lose.
you offer that as an attorney to hold on to the will for the,
I don't hold on to the will as an attorney. I hold on to a copy of it because if you do have a copy, it is easier to prove that a will exists. You only need one witness in that case as opposed to multiple witnesses. So it is easier. So I do keep a copy of it, but I do not keep the original. Some attorneys do, I just don't. And I found that when clients come to me and their attorney does keep the copy and then that attorney retires or they join another law firm, things just get lost. And then, it's just not a good look. So
wow,
yeah. So
interesting.
keep a copy. So that'd be the first thing. A death certificate needs to be obtained, and that death certificate needs to be filed with the court as well. From there, I would like to know what the decedent's assets were, because that's going to tell me what the probate's going to look like. And so on the front end, before someone, has passed away and they come to me, I work with them to put together a family inventory. And that essentially, says what all my assets are, who has them, who has, who to call, basically. Like, these are my bank accounts. This is who my investment advisor are. These are my other professional advisors. This is how you contact them, so that assets aren't lost, because that happens too.
Oh, I'm sure.
And so that, whoever's there to help you at the end, or whoever's there probating your estate, or whoever's there as your personal representative, you want to make it as easy as possible for them to get things done. Like, they're already dealing with your loss. You don't want them scrambling around trying to find like your passwords and, what is this bank account? And I think they have a life insurance, but I don't know who to contact. So like the green box exercise you have, that's something we do too. The intake form that I actually give to my prospective clients, ask them to provide kind of a lot of information, but then at the end of it, I give them back essentially a family inventory that they can update going forward. And that's so that, and it's one of those things, like, if I pass away, this file is here, go to that file. That file is going to have all my assets. It's going to have my passwords, or where to find my passwords. It's going to have my doctors, who to contact. It's going to have, if I've got minor kids, who you should get in touch with immediately to come and take them, so that, if I don't come home, you're not calling the police and the police are putting my kids in temporary custody with, some random like person. So yeah, so we're going to compile the assets so I know what's there, and also to what extent we need to do probate. And then from there, it's figuring out creditors, filing what's called a notice to creditors, which you just basically say, this person's passed away, we're giving you notice. If you're a creditor, file a creditor claim against that person. You wait 3 months, and then at the end of that 3 months, you look at the creditors. If you agree with them, you pay them, if the estate has funds, and then after that, you get permission from the court to distribute all the rest of the assets. Something that's relevant to you guys that I come across very often is when people have real property and they're looking to sell it in the middle of probate proceedings. And so in that case, the realtor needs to, kind of know in advance and pass that along to the attorney. Like, this is what's going on. We have property that we're trying to sell pretty quickly, because that's going to make the attorney jump on that and start working with the court to either get permission from the court to sell the property if needed, or reviewing the trust document to see if, that the personal representative can sell the property without that permission. But again, it takes some time to get it through the court, depending on the county. So that's something that your realtor would want to, connect with an attorney, with whoever's the probate attorney, kind of make sure that's going, because you don't want a sale to fall through because the personal representative, whoever, doesn't have permission to sell the property.
Yep. We find that all the time.
Yeah. So, and
we also find that people have, wills drafted in other states that don't have the right provisions in them to transfer real property in Florida.
That happens too. That's
so our standard of practice is, when we know we're dealing with an estate, we give it to our title company, and we have them research the title to make sure it's clear before we even put it on the market. So we don't we do avoid having a cancellation.
Right. That's really smart. Yeah, that's one of the things I say is like, because we'll do that all the time. We'll get a title commitment, Like, even if we're going through a probate and the sale isn't pending, at the end of it, if we know we're transferring the property, we'll do a title commitment afterwards, just to make sure we've covered all our bases, that there's not going to be an issue after everything is done before we close everything out. So I think that's a good idea to do.
Couple chats. Let's look at real quick.
Yeah.
Good morning. Good morning. Here's an interesting question. How do you pick a trustee?
So you pick a trustee. So, okay.
Somebody you trust.
Yeah. So I don't know, do you have that, the PDF that I sent to you? Maybe I can share my screen.
Oh, you can share your screen. I didn't check my mail it this morning.
Okay, let me share it. So I would say, the way that you pick a trustee is to pick someone who you feel would most closely carry out your desires or act in a way that you would act, because there's a lot of different reasons to get a trustee. I like to focus, when I talk to people about estate planning, like to start the focus and the priority on you, the individual, and making sure that you are protected from incapacity, that you are covered, like when it comes to risk and things like that. So part of what a trust can do is protect you in incapacity. So you can have the trust funded right now, then if you're incapacitated, the trustee would roll on and basically kind of keep your financial house in order for you, like when you couldn't do it. And that would be without the need to go to the court and have a formal guardian appointed for you, which again, is going to cost money, and it's going to be time, and it's going to slow down your ability to get the funds for the care that you need. So that's one of the reasons why you'd want to have a trust. So you want your trustee to be someone who knows you, who knows what your standard of living is, who knows the things that are important to you, and who you trust, who can, actually help you execute, on those things to protect you. Another reason
they should probably be expected to outlive you.
They should be expected to outlive you, or it's a person who, or you can put it in the trust document if you trust them, that they can appoint their successor. So that, like, if you don't have someone, because it's tough to figure out who would be a trustee. And so sometimes you get to that one person, you're like, that's it. And they're my bestie and they're the same age as me. It kind of is what it is. But you can leave them with the power to appoint someone else if they can't handle it anymore. Or you can find successors, or you can put some sort of mechanism in the trust to have certain people decide who your trustee is going to be. So, I've had people, their surviving spouse can be the trustee. Their financial advisor can be a trustee, their friends, their siblings, like really anyone who has the wherewithal to manage you and your assets is a good person to be a trustee.
Okay. And we have two questions that revolve around avoiding probate.
Okay.
One says, if you have beneficiaries and all your investments, including your bank accounts and a will and executor, et cetera, don't you avoid probate?
Right. You should. So probate assets.
Since somebody died intestate without a will.
Not necessarily. So probate it has to do with the type of assets you have. So a probate asset will be any asset that you own that's not subject to a beneficiary designation and not jointly owned. So then, yes, if you have bank accounts and you put a payable on death recipient, transfer on death recipient, or you have a beneficiary designation on those, then those would pass outside of probate. Homes.
There's a lot of responsibilities to prepare to die.
It's a lot of responsibility, but like you're in the best position to handle it though.
Now, while you're alive, right?
Exactly. Now, while you're alive, while you have capacity, you're in the best position to handle it. You don't want to leave a pile of crazy to, the people who are your beneficiaries. Like they're already dealing with your passing. And now they're just like, okay, now there's this bank account here that could have easily been transferred, but now I got to deal with it. Now I got to get appointed as a personal representative and all this other stuff. So, yes, you can avoid probate by having assets being properly titled and transfer. I just find that sometimes the issue is making sure that you do that family inventory so that you know what you have and that you title those appropriately or have them transferred appropriately. It's really about having a plan. And if you plan to avoid probate, you might be able to avoid it, but you could also plan to have a minimal probate as needed. So it's just having a plan, really.
Here's an interesting question. What if the estate doesn't have funds to pay the creditors? Does that fall on the heirs?
No. So if the estate, so the heirs don't get anything until creditors are paid. So if you pass away, you have creditors, you don't have assets, then it's too bad for the creditors. I mean, it is what it is. It doesn't go to any heirs because technically, if it doesn't have any assets, there aren't any heirs to inherit anything. So
That's the old, you can't squeeze blood out of a stone.
exactly.
I'm dead. My ability to earn income is gone, and you don't get paid.
Yeah,
Got it.
a break.
Can you have joint trustees or more than one trustee?
Yes, you can. You can have
That's a
multiple
good idea.
trustees. It all depends. So
There was another comment earlier saying joint trustees are a pain.
that's the issue. Yeah, that's the issue. If you have joint trustees and you have it in your trust that they have to act jointly, then they have to act jointly. And if there's only two of them, then it needs to be unanimous on every decision. And so, if you're in a situation where you're incapacitated and you have joint trustees and they have to work together to make every decision, that could make things a little more difficult for you to get what you need in a timely fashion. So instead of so you could have joint trustees, maybe think about maybe one trustee has authority to make certain decisions or has like, super power to make some sort of decision. And then other things they have to come to a joint agreement on, just so that you're not in a place where like, they're butting heads and you're not getting what you need or your beneficiaries aren't getting what you need.
Okay. I'll just check in the chats.
Mhm.
Interesting. This is not relevant, I guess. Can creditors force the sale of a person's home to pay off the debt? It depends.
Yeah, so let me think.
We'll think about
So
homestead first.
yeah, so homestead is protected. Let me think about this one. I haven't had that issue. Typically, when I've had someone who's been in that situation, they actually would prefer to sell the property to pay off the mortgage, or they want to keep the property. And the bank is fine as long as they're getting paid. The survivor just works with the bank to, take over the mortgage and continue making the payment, or they make a decision to sell it.
Well, I
But
think they were referring to other types of debt, like your
oh,
car.
other types of debt? No. So that's the whole idea of having homestead protection, is that
Protects your homestead.
yeah, it's your homestead. Like those assets, like that is your main asset, is protected from other creditors. So no, like, a credit card company can't make you sell your home to pay the credit card debt because it's, homestead protection.
They're
Homestead.
due to be repaid, but they can't force the sale of your homesteaded property.
Correct. And
They
like,
can force the sale of other assets.
yeah, if you have another piece of property, then they can attach to that and force the sale of that to get satisfaction. But that's why it's important to make sure your homestead is up to date, like check and make sure that it's accurate and that you have a plan for paying off these creditors, because you might have a piece of property that you really want to pass along through the family, but you also have these other liabilities that you haven't, made a plan for. And so your beneficiaries are going to inherit it potentially, but they're going to be looking at each other like, well, how are we going to pay this debt? And you haven't planned for it. So now we got to get rid of this property. It's going to be a fire sale. No one wants that. So good question. Yes, creditors could potentially force the sale of property. But if you work to have a plan to avoid that, you can avoid that.
It's amazing. Is there a certain type of deed on homesteaded property that will avoid probate?
So homestead property, so if it's owned by spouses, then it'll pass to the surviving spouse and you won't necessarily need probate. I think there's some people do what they call a ladybird deed.
That's the next question.
That's the next question. Yeah, some people do a ladybird deed. I personally haven't done them, and maybe it's just, the clients who come in, that's not really something that they want to do. Like there's other things that they, would prefer to do. I guess my problem with a ladybird deed is it doesn't really, for one, I think some of the law is uncertain when it comes to homestead protections passing to the recipients when you do a ladybird deed. Another thing on that is that it doesn't really say like how um expenses are going to be allocated when you do this like ladybird deed. It's like, okay, here's a property, but if it's to multiple people, it's not really saying, okay, well, who's paying for this mortgage, and how are all these things being done to kind of like, you know, deal with this deed. So I've just found that, you know, it gets it done, it moves it out of probate, but then
Doesn't address other questions.
exactly, it's just kind of sitting there. And if that's the only one piece of property that needs to go through probate to get title, that's not going to be a heavy lift, you know? So I don't know that you're really picking up that much inefficiency by doing a ladybird deed. And I saw someone ask the question, what's a ladybird deed? And it's just a deed that you can do during a lifetime where I think you essentially have a life estate. Like, so it's my property. I'll say like, during my life, I have the right to live in the property, but on my death, it's immediately going to transfer automatically to my beneficiaries. And so it transfers by title and operation of law, as opposed to right of survivorship, as opposed to, you know, having to go through court and transfer title after death.
Wow. There's a lot of subtleties that are not addressed. And I'm thinking, you know, our goal is to, you know, become a realtor for life for this customer. And so often we're in the first time home buyer relationship, right? And they're first time home buyers. It would really be truly advantageous to recommend, as they're starting their life together, to properly plan to protect their assets.
Oh, I agree. Yeah, I mean, I think it's one of those things. It's like you guys are kind of at the forefront of a lot of things. Like you have, you know, people who are starting their new family and they're buying a house. I mean, that's what caused us to move and buy our house. I don't know, 8 months pregnant with twins or whatever. So it was just like, we need a bigger house here. So, you know, there are a lot of people in that situation where they're starting their lives. They, you know, recently got married or they're engaged and they're coming together. And it's a good time to start thinking about all of that stuff and protecting what you've worked so hard to build. Because I mean, that is really a big part of estate planning is it's, you know, I think a lot of people get caught up in like, oh, well, I don't have significant assets, or oh, I'm too young, blah, blah, blah. But it's really about like, you've worked, you have something to transfer, whether it's like, you know, assets, like actual physical assets, or it's intellectual assets. Like, come up with a plan to transfer it and to preserve it. And don't leave your loved ones, don't leave your loved ones in a position where they're like scrambling or fighting or trying to figure stuff out. And so you guys, yeah, you're definitely there. And I do think that's a good value add to say, hey, have you thought about this?
Mhm. So what does it cost? Like, let's say we want to offer a consultation.
Mhm.
Let me get this straight out of my mouth. This is one of the easiest things to pass on or put off and avoid.
It is.
Right? It 100% is. I've been saying for decades that I need to do this, I need to do this, I need to do this. And I just push it off, push it off, push it off. Many of you have written me since the emails they sent yesterday saying, I really need to get on this, I really need to get on this, I really need to get on this. And it is one of the easiest things to get put off, to push aside. So I would imagine a consultation with you would be a first step to, because awareness. I've got this thing I say all the time. Awareness gives you flexibility, flexibility gives you options, and options give you power. So making our customers aware, not good to say, that's a good statement.
Yeah, it is.
If we make our customers aware that this is something they should be considering,
Mhm.
then that gets us some options, and then we can make an introduction to you, and you can do your little family inventory process,
Mhm.
right? And that would be a start.
That's a
And then the
start.
question is, you know, what are the basic costs associated with basic planning for not a super ultra high net worth individual?
Right.
This is not
So
just for wealthy people, by the way, guys. You can see.
no, no, it's not. So there is a hierarchy of estate planning. Let me share my screen.
I found your email. I put it up if you want.
Okay, yeah, please do. Because I just something popped up. I don't know. I'm really technologically challenged. So
There you go.
thank you. So go to the estate planning hierarchy. That's me.
Yeah, I'm gonna put this up. You can screenshot that if you want for Jennifer's contact information. Or write it down. I'll bring it up at the end too. Estate planning hierarchy.
Yeah. So when someone first comes to me looking for estate planning, like you said, I send them the family inventory, and this is before we even discuss fees. I send them the inventory, and when they provide the inventory back to me, that's when I schedule like, an introductory kind of call, because I'm not able to tell you how much something costs until I know what you got going on. And it's not even like financially what you have going on. It could be, a very modest estate or modest assets, but there's a lot of complexity there. Like, I want to set up a pet trust, or I have a blended family. I want to do this, that, the other. So I need to get the family inventory back before I can say it's going to cost X, Y, and Z. So, but I
How much
typically
commission do you charge? It depends. That's
no,
just my famous answers is it depends.
it depends. It depends. Sorry, it depends. I mean, it's not going to be like a LegalZoom sort of situation, because I'm actually kind of sitting with you and making sure that we kind of hit all the bases. So there's going to be, it's not going to be that, but there's different levels of what you need. So I would say the first one, the beneficiary designations, asset ownership, family inventory, risk management, financial literacy. Those are all the baseline things that you need to start your estate plan. And I think everyone needs those things. And there's things you don't need me for. Figure out your beneficiary designations, confirm that your asset ownerships are what you want. I can send you the family inventory. Like if you guys email me, I'll send you what I send that I use to produce a family inventory, just so you can start marshaling those assets. Risk management, make sure you have home auto insurance, you have disability insurance, long-term care insurance, all those things to make sure that you are taken care of and you are protected. Financial literacy, start with making sure that you have basic financial literacy. If not, hire a professional, a financial advisor. Make sure your retirement is going the way you need it. Those are the baseline things that are part of an estate plan. And that's where I would start people off. And then from there, it goes to, guardians, medical agents, financial agents. So again, I think everyone needs that. If you're incapacitated, you need to have someone that you trust to come into that role to make those decisions for you. If someone comes to me and just asks me to do those, I can do that. That's just fine. Just making sure that you have your body taken care of, like someone who's going to make those decisions for you. That's the next level up. And I think everyone needs it. And then you look at having a last will and testament. A lot of people are just like, hey, that's all I need. Like, I'm not trying to do any long-term planning. I just want to make sure that, whatever assets I have that I might not have swept up in the beneficiary designations go to the people that I want to do. That's fairly simple. You do a last will and testament for that. The next level up would be having a revocable trust, or and also potentially LLC agreements to house your investment property, but investment assets or businesses. So the thing with the last will is basically says who gets what, but it doesn't have any protections for you, like, or any long-term protections for you. So if you're incapacitated, a last will isn't going to be able to be used to manage your finances for you. Whereas a revocable trust can help you as you age or in incapacity, as long as you have a trustee that you trust. If you have long-term plans for, beneficiaries, like it's important for me that, my beneficiaries actually have a job or graduate from whatever before they receive, money from me. You would want to do a revocable trust for that. A will and testament isn't going to do that. And then anything after that is just more advanced planning that I feel like most people don't need. But like you're talking about, like planning for tax savings. And right now the annual exclusion is $12.9 million. So, not a lot of people really need to get into the level 5 planning, but like 1 is something anyone can do, doesn't even need me to do it. 2 is something that's fairly basic. You could probably do it on your own as well. 3 and 4 is when you would, start reaching out to an attorney just to make sure all your bases are covered. And again, it's not necessarily about assets. It's about like protecting yourself, your family, making sure what you have accumulated goes where you want it to go, and that you're protecting, your family's protected.
Do you ever do like seminars on even step one? I think a lot of us would be confused about.
I could. Yeah.
Beneficiary designations,
Mhm.
asset ownership, family inventory, risk management, and financial literacy. I mean, right there. I mean, I know I've got insurance on all my vehicles. I've got insurance on my houses. I've got umbrella insurance against my personal, if I get extra coverage in case something's better than that.
Mhm.
But that's about all I know.
I mean, that's pretty good. That's pretty good. Yeah, I mean, I like those are things like the insurance piece of it. I would probably loop in someone who does that. But I mean, that's the high level thing is like if you're disabled, that you have disability insurance, that you have long-term care insurance, that you have life insurance for, people that you want to have those assets, um, home and auto, making sure those things like basically like risk management is just making sure that if there is an accident or a judgment, that that's going to be covered by someone else and not you. It's not going to drain your financial assets. It's not going to impact you and your retirement or your family's ability to do what they need to do. So that's how I would summarize risk management. And to go into further detail, I mean, I could definitely loop in like colleagues who are in that space to do it. And the same with financial literacy. I like to stay in my lane. So I know it's important to have, be financially literate to know like, okay, I have this plan where this is what I'm doing right now. This is what I need to get to in retirement. And you need to have the steps in between, but I'm not the one to put those steps in place. And maybe some of you guys are. If not, there are plenty of, financial advisors who can help with that process, but that's like all part of it.
Hey,
And
listen,
then
guys, even the attorney punts to another expert. A
it's a
lot of
lot.
agents feel bad when we say, it's really outside of my wheelhouse. You really should talk to an attorney about this. And I say it all the time. Even though I
Mhm.
might know the answer, it's outside of my wheelhouse, and it might be a better answer than the answer that I have. Right. So even though I might know it, but I'm just glad to hear you say that. Sometimes I loop somebody else in.
Yeah, definitely. I mean, at the end of the day, you want to help,
Mhm.
and helping is sometimes just making those connections so that people can get to what they need to get to.
Here's a question. You addressed this earlier, kind of. Michael asks, what if your assets, home and rentals exceed $1 million? And you had talked about tax planning, estate planning benefits, isn't you said $12.9 million?
Yeah, it's 12.9 million per
So if
person.
your assets exceed $12 million, you got to pay tax, death tax.
That's where it starts. But if you're married, then each of you combined, it's 12.9 plus the 12.9, so you get to like 24 million if you're married. But there is tax planning if you exceed that can be done to save on that. There's, gifting during your lifetime. There's making transfers into irrevocable trust because the exemption is what it is. And by the way, in 2025 is going to be cut in half to $6 million per person. So I think you're going to start seeing more people who are going to be in need of tax planning. But really, when you think of estate planning, it's like you have the money that you have, but if you have a business that's growing in value, then you would want to get that out of your estate some sort of way and like transfer that out, because what you don't want to have is an appreciating asset in your estate when you pass away. If you can, afford to gift that to someone else. So then you get not only that asset out of your estate, but you get the increase in value out as well. And especially like if it's an issue now, like right now, the exemption is 12.9 million, it's going to be cut in half, but you can still take advantage of that 12.9 million now. So if you had like an asset that was worth that, it would, if you could afford it, to somehow transfer it out of your estate now, so that when it's cut in half, you're like, oh, well, it's already out of my estate. It's not going to be subject to tax. I'm good. So there's definitely tax planning that can be done once you get to the higher income levels. There's also income tax planning too to consider now. And the thing with income tax planning is that when you transfer an asset to a beneficiary, if they want to sell that asset, they're going to recognize capital gain. But the good thing about, not death, but like the good thing about receiving an asset on death, as opposed to like a gift during life, is that when you pass away, that asset is treated as if it's called a step-up basis concept. So it's like, instead of a transfer basis. So it's like, okay, you have a house, you gift it to someone. If you paid $5 for the house, then they're going to be treated as if they paid $5 for the house. And then if they go sell the house for $10, then they're going to have to pay that tax on the $5 difference, right? So that's if you gift it to them during life. But if you wait and transfer that asset during death, so if you originally bought that house for $5, but it's worth $10 when you die, when you transfer it to them on your death, they're going to be treated as if they paid $10 for that property. Like whatever the fair market value is at the date of death, that's what they're going to be treated as paying for it. So if they turn around and sell it and the property is worth $11 or, whatever the fair market value is, they're going to have much less tax to pay. So like, that's kind of something to think about now, income tax planning. Like if, like I would be thinking about something like that. I'm not in the $12 million mark, so I'm not thinking about that, but I am thinking about capital gains and income tax planning and like gifts during life and how to avoid some of the income tax stuff.
Fascinating. And you get into that too?
Yep. My background is tax. Before I came here, it was tax planning. And so I've been able to kind of take that tax knowledge with me to the legal field. So now I do estate planning and tax.
So for the question of what if your assets, home and rentals exceed $1 million, there's nothing. It's not
Yeah,
tax.
you're good.
You're good.
Fine from that.
Okay. Didn't hear the 12.9 million. Okay.
Maybe.
Yeah. And mom, family inventory is basically your green. It's an inventory of all your family assets.
Yeah, it's and again,
Like the green box exercise, making an inventory of your bank accounts and your checking accounts and which you've done a lot of.
yeah, and
Your mortgage payment, who the mortgage goes to, your account numbers.
yeah, and the family inventory that I do,
If you send me that, I'll send it to the whole team with
okay,
your
yeah,
contact information.
yeah, and the one that I do, it's it collects all that information, and it also asks for like, okay, well, kids' names and just kind of who you'd want to be your trustee, who you'd want to be your agent, who do you want to have short-term custody of your kids if something were to happen. Just all
Wow.
those
What if
things.
you got this to your customer and they put into their planning that they want their family to use you as their real estate agent? You could actually do that. So it's called a direct.
Yeah. Actually, yeah, like I mean, there's a spot in there for professionals. So yeah, yeah.
How cool. Here's your closing gift. You get okay, great. Okay. Next slide.
Well, that's it.
Oh, that was it.
I guess if you go back to one of the other ones we kind of skipped over. So this one, so a lot of people actually go up one more, the priority one, next page.
I'm trying to get up there. My mouse is
Oh,
that's the first one. That's your second page. There we go.
this one. Yeah, third page, I guess. So prioritization. I think when a lot of people think of estate planning, the first thing they think of is like, okay, well, what assets am I going to transfer? How am I going to transfer these assets? And because it can be a very overwhelming process, and so what I like to do is kind of focus people with these two slides. So like prioritize yourself first. Like it's okay to be selfish in this instance. Like start with you, prioritize your care during incapacity. Make sure that you have something in place so that what's going to happen to you when you need it, so that's why I talk about like the
Long-term
risk
care
management,
insurance.
financial literacy, all of that stuff, because you need to make sure that you're in a good place before you move on to other people. It's kind of like the whole airline thing, make sure you have your own mask on before. Exactly, right? And so like that kind of lines up with our estate planning hierarchy with the risk management, financial literacy. You start to focus on you, make sure you're good with your documents. And then the next step would be your family. So that's when you're thinking about, okay, so if something does happen to me, do I have life insurance that could be used to support, my kids and replace my income, or whoever I'm trying to support, what other dependents I'm trying to support? Do I have beneficiary designations on everything so that, if something were to happen to me, other folks could get access to it easily? Do I have, pre-need guardianship paperwork done for my kids so that if something were to happen, I'm telling the court, these are the people that I want to be their guardians. The court's not going through some exercise trying to figure out, okay, well, this one's a blood relative. They look good on paper, so we're going to put the kids with this person. You don't want that. Like, because after that would be future generations. So that's when you start to look at, okay, well, do I want to have a long-term plan where I am incorporating stuff for future generations, grandkids, or, you're moving out even further to the community? Like what legacy do I want to leave? But, you start with you. I think that's a way to
A great
not
example.
simplify it, but just start the process like bit by bit. And then that kind of dovetails into the hierarchy. Again, like start with the low-hanging fruit, get the things done that you can get done on your own, and then pick at it, gradually, get to where you need to get to have all 5 things. Like you don't have to go to an attorney. You could go to an attorney and they can help you with all the things at all, all the time. But like there's other ways to get it done.
Fascinating. Well, this has been very helpful and eye-opening, and I'll say it again. It's the easiest thing to know you should do, and the easiest thing to put on the back burner and not do.
Mm-hmm.
So as we come into the end of the year, and I don't care if you're 24 years old or if you're 86 years old, everybody needs this stuff.
I agree.
Nancy said very good information, and thank you.
Oh, you're welcome.
I've thought about that with one of my sellers being a professional realtor to sell their properties. How does a guardianship work with step parents versus biological parents that are not in the kids' lives? Ooh, that jumped up to one of these high levels.
Yeah. So the situation is that have the biological parents given up custody of the kid, like terminated their parental rights?
The answer is going to be, it depends.
I mean, I think, and this isn't my specialty, but just off the top of my head, I mean, I think the court kind of puts a preference towards biological parents, if they have not given up parental rights. So, I mean, while everyone's alive and doing okay, I mean, if the step parents are the ones who are the step parents, if the non-biological parents are supporting the kids, I would start by having a conversation with the biological parents and maybe seeing if they would be willing to execute documents to either give up their, custody of the kids to make it official, or at least do a declaration of pre-need guardian so that if something were to happen to them, the person who's currently taking care of the kids is named as, their guardian. So at least you have that situation where like the biological parent is designating the existing, I guess, step parents to continue to take care of the kids.
Yeah, those are real serious examples of things that need to be planned on.
They do, yeah.
And addressed.
It's a lot. It's a lot.
And then upon death, if your will was done the right way, those questions would be answered.
Some of them would. The will, it's not going to, I mean, you could designate in your will the guardians of your kids. We usually
What was the one thing you told me about when we met that led to the disposition of your remains?
Yes. So I got a phone call from a potential client, and she was from out of state, and her mother had just passed away within Florida, and who the brother was taking care of the mom. And there was a family dispute between the brother and the sister. The sister, said the brother was keeping mom away from him. It was just a whole messy thing. And sister insisted that mom wanted to be buried in Minnesota or whatever state in the Midwest. And brother was like, no, she's going to be cremated and her ashes are going to be scattered. And, this woman called me and she was just like, well, how do I fight this? What do I do? And at that point, there really isn't much that you can do because there's statute that gives priority to
You come
who
back to life and then you tell the kids to have
and
a
fill out this document. Yeah. Like, I mean, that's the kind of the thing. It's like at this point, there's not a ton that you can do. You know, he has your mom and he's been with her for the past few years. It's kind of on him. You can go to court and fight it out, but that's just going to be a waste. But what mom could have done was execute a document like declaring, you know, this is the person that I am making responsible for my remains on my passing. And this is what I want to have done. Like, I want to be cremated and my ashes scattered here, or my ashes given to this person, or I want to be buried. And this is the cemetery that I want to be buried at. Like, those are things that you can do to help avoid situations like that.
right.
Yeah.
Okay, so this is not intended to teach you to be an expert at wills and estates and planning, but to make you aware of the importance of wills and estate planning, right? And as a trusted advisor to our consumers, to make them aware of the importance. And right now, you got a friend in the business. And actually, in the chat, Jen wrote in a personal financial advisor she's impressed with, and she shared his contact information. So if you're interested in that, check the chat. And I'm putting Jennifer's page up here for contact information. So you can see her office numbers. That's her cell phone number, I guess, huh?
That's my cell phone number.
Wow. You get her cell phone number and an email address.
Yes.
And if you'll send me the family planning document, family inventory document, I'll circulate that to the team with your contact information on it. And that's the first thing. You get that out for free. So it's going to be a wake up call to start putting your affairs in order, right? Be a nice thing to do for your family. I think that's the important thing, right? It's probably the best thing you could do. How many stories have we heard of the surviving children going crazy, pulling their hair out, trying to undo the mess their parents left them when they died?
Yeah.
Right. So if we can help them avoid that now, it's a good thing on our side.
Yeah, it's terrible.
So, Jennifer, I'm very glad to have met you at the Easter Seals event.
Me too.
Agents,
Thank you for inviting me here today.
If you need legal counsel on this type of stuff, I would certainly give Jennifer a call. She seems very well qualified.
Thank you so much.
You're welcome. We have 4 new chats, so much thank yous. Oh, Lauren said, what's your rate for a consultation? Where does it start?
So my rate is $400 an hour for a consultation. If it's something that's like 15 minutes and we're just kind of discussing whether you want to move forward, I'm happy to just have that conversation with you off the clock. But if it starts to go more than that and it becomes a full-on like planning session, then I would do my rate per hour. And then if you decided to move forward with actually doing the plan, then like that would be waived and, you know, it'd be kind of absorbed into the full fee. And I typically, once I have the family inventory completed and we have a conversation, I know what you're going to do, I can provide like how much it'll cost. So yeah, that's how it works.
Regina, just scroll up in the chat. You'll see a JK and a long sentence. The paragraph questions in the chat. I'll leave the chat open for a couple more minutes. Your message down here. You're getting lots of thank yous.
Oh, you're welcome. Thanks for having me here.
Good job. And so do you work, just curious, do you work from home now or do you actually go downtown every day?
I go downtown every day. This is
my God.
This is my office.
Not a bad commute from Euclid to downtown.
No, it's like 10 or 15 minutes. And I actually don't mind it because just in the house all day, I'm like, I gotta get outside. Yeah, and I'm right by Eulalie and the Riverwalk, so I don't mind coming to work every day.
Nice. Okay, I'm just trying to leave the chat open for a minute.
Yeah.
And then we're good. Okay, so once again, on the screen is Jennifer's name, email address, and phone number. And I want you guys to think about this as for yourselves, number one, because the first rule here was take care of yourself. And I think as a benefit to our customers, would be a nice way to show that you care and remain more relevant in their lives too. So that being said, we're going to leave a couple minutes early and say happy Thursday.
Thank you so
South
much.
Tampa party tonight. I think it's at 5 till 8. So our South Tampa office on Henderson, right off Dale Mabry, so right up the street from it.
Very cool. Very cool. Nice. Enjoy it.
All right. Thanks, everybody. Happy Thursday.
Thank you again. Bye.
Bye.